If you're in a civil trial in Massachusetts, whether it's in district court or in superior court, at the end of the proceedings, the defendant can and often will make a motion for a directed verdict. And essentially, what the defendant is doing by making that motion is saying to the judge that after hearing all of the plaintiff's facts and all of the evidence that's been presented by the plaintiff, there is no grounds whatsoever for the matter to be submitted to the jury to be heard. So as you can imagine, this is a pretty high demand that you're making on the court. You're asking the court, after wasting the jury's time and everybody's time and effort, to simply rule in the defendant's favor without giving the jury an opportunity to decide the matter. It is possible, it can be granted, though it's unlikely to happen. The judge is unlikely to grant the motion. In fact, the Supreme Judicial Court has said even when there's grounds for a judge to grant a directed verdict, that, quote, the better procedure is for the court to allow the case to be heard by the jury. So the Supreme Judicial Court has said even when the judge can grant such a motion, it's a better procedure to let the jury decide anyway. Nevertheless, if you're a plaintiff going into a civil case, be ready for the defendant to make such a motion at the end of the proceedings. And if you're a defendant, you may want to make one of these motions just because it's worth a shot. Who knows? You may get lucky. The judge may grant it. It's unlikely, but you may as well do it because you can. If you have questions about litigation, directed verdicts, or anything like that related to the law, send me a message or send me an email, and I'd be happy to talk with you.